good morning to you. Thank you so much for keeping it Y254. We're pleased to have you on this fantastic Monday morning. This is another edition of Hello Day, and we trust that you had a fantastic weekend. Now, that SMS number is 22162 if you'd like to engage with us. Of course, please begin your text message with the words YM254, and we'll be sure to sample some of your text messages right here on Y254. And those social media platforms, Kamakawa, they are YM254 on Facebook, as well as, of course, Instagram, as well as Y254 channel on Twitter. Now, this being a Monday, it's all about current affairs. And so we get into a discussion, of course, that has been making headlines. And I'll tell you, you're definitely going to enjoy this one. On April the 27th, Kenyans actually bid farewell to veteran politician Kenneth Matiba, who, of course, is remembered as a pro-democracy hero. Now, however, many in particular elders in Moranga town were actually shocked, absolutely shocked by his wish to have his remains cremated, saying that it actually was against tradition. But you know what? It was all in his will. And this actually got us thinking, how many times do we even think about writing a will? I know we're young, this is a youth channel, but how applicable are wills for the young? So today we actually are very, very pleased to have, for the very first time, Advocate Ruth Kibebo in studio to advise us more as we get into the discussion, last will and testaments, and how applicable this is for the young. Karibu sana to the studio.
Thank you so much.
We're happy to have you, Ruth.
Thank you so much.
Okay, so we know this discussion actually got spawned by, Kenneth Matiba's funeral, or the whole cremation story. But we actually decided thinking, okay, what about wills for the young? Could you actually first start off by giving us a definition of what a will is?
Okay, a will is a legal declaration by a person of his wishes to dispose of his of the way he wants to dispose of his property after he's dead.
Okay, and what is so important about it, though?
Well, a will is very important.
Yeah.
Why is it important? A will is important because it gives you the opportunity to decide how you want your property to be disposed of when you're not alive. And it also avoids a lot of conflicts, confrontation that can happen between your children. Yeah. If you're a polygamous man, your different households, and if you have decided how to dispose of your property, then that avoids too much conflict that can come in if there's no will. It also allows you to decide who to give, your favorite child, you can choose like you can choose to give something to someone that one of your favorite children. You can decide to give them something, and of course it's something that should definitely be adapted.
Okay.
Yes.
Okay. I understand that there are different types of wills. Most of us just think, okay, it's just about writing something down and then you're good to go. But what are the different types of wills that are out there?
We have two different kinds of wills.
Yeah.
We have oral wills and we have written wills.
Yeah.
Oral wills have to be valid within the first 3 months after the person has passed away. So if you have a will and you pass on after 3 months, the will not be valid and it cannot be enforced. Yeah. So there's an exception to that rule, of course, under Section 9 of the Law of Succession Act, which is a law that governs the validity of oral wills. And it says that if a person is a mariner or a person who is in active service or in the armed forces, that exception falls their way, because their wills, even their oral wills, will still be declared valid even though they have passed away after 3 months of making these wills. Something else, Shiko, these wills have to be witnessed. We call that attestation. Okay. So there has to be at least 2 witnesses to the will. If it's an oral will, there has to be at least 2 competent witnesses present, and the witnesses have to be persons of sound mind and persons of who are over the age of 18 years.
Yes.
The same applies to written wills, and the form of validity of written wills is also governed by Section 11 of the Law of Succession Act, which is a law that governs how a will should be made.
Okay.
So written wills also have their own. They're supposed to be in a certain format. Sorry, not really a certain format, because we don't have an exact format for a written will.
Right.
We just have rules, that govern the validity of the written will.
Okay.
The written will also has to be attested, meaning that it has to be witnessed by at least 2 competent witnesses.
Yeah.
And the competent witnesses as well have to be persons of over the age of 18 years.
Yeah.
And should also be of sound mind.
Okay.
The person making a will also has to have capacity
to be able to
write the will. Section 5 of the Law of Succession Act is very clear that the person has to be of sound mind.
Yeah.
And the person also has to be and the person has to be over the age of 18.
Okay. Okay. All right. Getting into this discussion, the first question is, when we think about wills, we think it's something for the old.
Yes.
Who in their right mind under the age of 25 or 35 is going to be thinking, okay, by the way, a will is something that I need to get into. But, the reason probably a young person would wonder why I should actually get a will done is because, do I really have any assets? What am I actually handing down, Ruth? And so why is it important even for young people to actually consider having a will?
Okay, well, Shiko, we work so hard to make this money.
Yeah.
And we also work very hard to acquire this property. So if you've worked so hard to acquire that property, why should you not have a say on how the property is going to be distributed if you're not alive?
Yes.
And we all know that death is certain, for the human being. It's
inevitable.
It's inevitable.
Yeah.
It's inevitable. So it doesn't matter how old you are. You don't have to be 20, you don't have to be 50, you don't have to be 30.
Yeah.
Or even 19, and you have property, but you still want to have a say on what happens if I'm not here. I think it's just about thinking over and beyond, thinking beyond where you are, wanting to have your property distributed in the way you would want it to be distributed if you're not alive. Okay. Regardless of whether you have kids or not, you might have a favorite person, you know? You might have your mom you might even have differences. Yeah. Yes, and imagine, and you've not written a will, and unfortunately you pass away, and you never agreed with your mom, you never agreed with your closest family. Yeah. Okay. And your property might have to be subjected to intestate succession. Imagine your property being subjected to intestate succession, meaning that there's no will, and it has to be distributed to your closest family members that you never agreed with, that you are never together with. You have no say. Yeah. They will benefit. And yet you probably had a child somewhere. Let's put that aside. Let's say you had a friend somewhere that you really like, that is your favorite friend or something, and you would have wished to have that property divest into this person. Okay, let's discuss now that word property, and let's talk about assets. When we say that we are handing over these assets, as young people, we have not yet reached that level of saying, okay, you know what, I have property, I have assets. Okay, in such a situation, what are you advising young people to do in terms of having a say as to what happens next with what they own? Is there a difference? Does it qualify? Does a will qualify for someone who doesn't even have that one title deed that, Like we said earlier, a will is basically a legal declaration on how you would wish to distribute whatever property, free property that you have, or property that you'll be legally competent to distribute or to dispose if you're still alive. So that can be debatable, because there are factions that will be of the opinion that personal and household goods should not be subjected to a will.
So that means your TV, your fridge, your couch, your... Okay.
Yes.
Yeah.
But then again, when I look at the strict definition of a will under the Law of Succession Act, it says that it is your wishes to dispose of your personal, your property. Yeah. Your property. So the definition of property then should probably be the issue in contention. Right. What is property for purposes of a will?
I like that. I like that. Yes. What is property? Okay.
So what is property for purposes of a will? Yeah. It could be that, it could be that property that you bought somewhere. It could be that land, the immovable property. It could be immovable property, which could, it could be movable assets and immovable assets. It could be anything that you basically own. Okay. Yes. That you would wish to distribute or to dispose of. In a certain manner. Okay. Yes. Okay. Which could be of high value, by the way. It's not to downplay that if you don't have land, if you don't have, whatever you own isn't important. Okay. I know there's lots of risks that come with not writing a will. And one of the key questions that people always like to bring up is unclaimed assets. I was just thinking, Ruth, and we actually discussed this before we got on set, and I remember mentioning to you that a lot of people actually don't think about what happens to the monies in the bank. Listen to this point. What happens to money, for example, on M-Pesa, if someone does die? These actually are classified as unclaimed assets. What really does happen? Because these are some of the risks that people do come across. Well, Shiko, I do agree with you that we have the issue of people not claiming assets, or people dying and their assets not really being accounted for in terms of not being put through succession for purposes of benefit for their beneficiaries and other people who will be entitled to the property. Well, the issue of unclaimed assets, of course. Yeah. I think it's a very interesting one. Yeah,
it's definitely food for thought. We have to discuss about that. Yeah.
Food for thought. And definitely it's something that needs to be.
Yeah. By the way, I'm telling you, I when you talk to people who probably work in banks, they will tell you the amount of unclaimed money that is in the bank it's ridiculous. Yes. Yeah. Okay. All right. So speaking about that, let's discuss one issue that has actually come in from my director, who talks about young entrepreneurs today who actually have gotten into business ventures together. So we would call it co-ownerships. Yes. How does one go about, navigating such a situation in the event that there's death? And, we've got one partner, you've lost one partner, you've co-owned something. It's not unheard of, to hear that,
it's people not unheard of, Shiko. I'll give you an example of joint tenancy, which would be the co-ownership of property. Let's say a piece of land. We both appear as the registered proprietors of that property. And one of the basic, one of the aspects of a joint tenancy that if someone died and we co-own this property together and a joint tenancy is presumed, then the person who is surviving actually gets the right of survivorship over that property, and the person now owns that property alone. So your right is extinguished upon your death. Meaning that even your survivors or your beneficiaries would not be able to claim anything. But of course, Shiko, like you said, we had this discussion earlier. If it's a situation where you have, let's say, a company and your different directors, of course, companies are regulated by their own articles and memorandum of association.
Yes. Yeah.
And a company has a legal persona. So your death does not necessarily affect the existence of the company. So probably the kind of question that we'll be asking would be, what will be the procedure according to our articles, according to our memorandum, on the way forward when someone is dead, when a director is dead, what happens? Are the shares inherited by his estate? What happens? You know?
And this is now where you see a lot of cases where people, we go forth, we open companies with our friends, we don't bother to actually read the memorandum of association and understand how the company should operate.
Exactly.
Yeah.
And the system has made it easier because you always have the draft, the standard format of articles of association.
Yeah.
And nobody bothers to go through the articles. I mean, who wants to go through?
It's like too many pages.
Yes. Who wants to go through 10 pages of a document and you're not even a lawyer? You're like, But for lawyers, you know, you have to go through it because it's your job.
Yes.
You know, you're hired to go through this, the articles of association and make sure that whatever is on that document is what your client actually intends to have bound, to have, to be bound by.
Okay, okay. So please read. That's the motto.
Please read. Even the fine print.
Yes.
Please read.
Yeah. Okay, but let's talk about cultural beliefs, okay? Being a factor as to whether or not one will actually have a will. It's been said for years it is completely un-African to actually have a will. Look at in the case of Kenneth Matiba. I mean, you know, the elders in Moranga were saying, by the way, this is not part of our tradition. Has cultural beliefs actually been a hindering factor from your experience when it comes to, you know, trying to advocate or encourage people to actually have a will done?
Definitely. Definitely. Like we've had this before. People always say that if you write a will, you're preempting your death. You're wishing your death. You know? But that's not the case. A will is something that just protects your interests, your wishes. If we looked at it as that opportunity to have a say, even beyond the grave. Even when you're dead, to just have that say and to be able to say, I want this to go here, I want this to go there, my favorite baby will get this, my favorite daughter will get this child of mine was very good to me, I'm going to give him 2 acres, this one was not so good, I'll give him 5 acres, I mean I'll give him a 1 acre or half an acre. You know, the issue of how big or how small the person gets is never going to be contested. And something else I have to say, Shiko, which is very important. The courts are very, very, very keen to maintain the wishes of a deceased person. The court will not easily alter a will or alter whatever a deceased person actually wants to do with his property. You know?
Yes.
So we have to remember that when you're writing that will, having it invalidated is on those very, very crucial. Those crucial, unless the formality is not okay. Because you can find, I can give you an example where we see a will, someone has written a will, but the process of attestation means the execution, the witnessing, the people who witnessed did not sign all the pages of the will. They only signed the last pages.
Oh, wow.
Wills have been invalidated on such grounds.
Wow, just like that.
Because the tenets of attestation were not followed to the letter. You did not sign every page. So if the testator is signing and they sign and you have to witness right next to the testator's signature.
On every page.
Yes. And if you're not educated, sorry, I won't use the word.
Okay.
If you're not literate, sorry. If you're not literate, and some people who are not literate, some of them don't know how to sign.
Right.
You can affix a mark, which could be your thumbprint. It could be something. Just affix something and let it be witnessed by the other independent witnesses. And that has to be done on all the pages. Yes.
Okay. How do we give a voice to a married woman in today's society when it comes to a will? Because for a very long time, we've seen this growing up that, you know, of course, it is the man who has the say about how property is distributed. From a legal perspective, what does it say about, you know, how women can go about this?
How women can go about wills? Well, women have been considered to be a marginalized group. But the law has considered them in so many ways. Section 5(2) of the Law of Succession Act, which is the law that deals with intestate succession, or this issue to do with succession basically, says that a married woman just like, you know, an unmarried woman or like any other male person has a right to write a will. They have a right. Yeah. So it is clear. It's in the law. Nobody stops a married woman from writing a will.
Right.
But then again, before you think of doing that will, ask yourself, do I have the legal capacity, the competence to dispose of this property by myself?
That it's not joint.
It is not joint. Now that brings us back to the question of, is this matrimonial property? If I was if I'm married, and I want to dispose of something, let's say the house we are living in with my husband, which is definitely a matrimonial property. Can I go about doing it by myself without involving my husband?
No.
So why would I write a will and dispose of something that someone else has vested interests and I cannot competently dispose it when I'm still alive, you know?
And that is the challenge that we always get, because a lot of things have been co-owned.
Yes, but then again, there's this concept of being a femme sole. It's a legal concept. Where you actually have attained this property by yourself. If you get married, maybe in your late, you know, a bit late, and before you get married, you have acquired some property. You've bought a house, you've bought a car. You know, you've bought several properties, let's say land here and there.
Women are independent.
Exactly. You know, women, women are, So if someone has acquired property and, of course, this was not while you were still married, this property is yours.
Yes, isn't it?
It is yours.
So now that is what you can gladly put in your will.
Definitely.
Okay, but matrimonial,
matrimonial property would be something else. Because in fact, nowadays it will be very difficult to even dispose of anything without involving your spouse. If it's property, if it's land, you still need to get a spousal consent from your husband. If you're married, from your wife. You know. You know, it's always there's always something tied to
okay. I know, I mean, it's a very far-fetched idea discussing this on a channel like Y254, but I always believe that having that kind of information really does help, because going forward, aren't we going to get married? Aren't we going to have kids, even if we are young, you know? So this is the kind of information that you probably need to keep in mind, because you do find a lot of people that contribute to this show, Ruth, are just recent, they're newlyweds, they probably have one child, and so if we're thinking about the future, these are things that we do need to keep in mind, right? And that brings us to our next question, even as we're about to wrap up, Ruth. It's the issue about polygamy. It's legal now. From your perspective, was passing of this marriage bill for men marrying more than one woman actually a good move, especially in the case of a will? Because now look, we have more than one woman in the home. This guy has property. His will says Ruth will get it. Maybe Shiko gets a fraction because he likes Ruth better than Shiko. So then now what? Now it leaves Shiko and Ruth in problems.
Yes.
Okay. Tell us.
Well, Shiko, like laws are meant to reflect the reality on the ground. So we can't say that it is the Marriage Act that made men start marrying more than one wife. It only legalized something that was already existing. You know, men still married more than one wife, under customary law, because it was allowed. My grandmother, or a relative from somewhere that I know, was among the 5 wives that the husband had. You know, there were so many in the past. Men were allowed under customary laws to marry more than one wife. So it is not an alien concept. It is something that has always been there. And it has only been legalized or brought to light. Or for those people who are feeling like it's not something that they would accept or something, it is a reality that was already existing. So the only issue that comes into play, which of course I think is good, because it caters for those women that would have found themselves in a precarious position of their husbands leaving them and pretending there was nothing while they had actually been married under customary law. So now that it has been made official, even that other wife, you know, can now be considered you know,
yes,
a wife for purposes of, you know, any legal purposes, because they are now even getting certificates.
Right.
They are now legally recognized. So the issue of polygamy and succession, of course, there is a problem. Because if you have more than one household, and unfortunately you pass away, then property is distributed. If you have no will, the property will be distributed among those people, those households, counting your wife as a unit. You know? So if you have 5 households and you have 2 children, I mean, sorry, it's going to be, the distribution of the property should be according to the number of children in each household, and counting your wife as a unit. Whatever, you know, if there's a wife. So that means that if you have 2 children here, you have 3 children here, and 1 child there, the household with the least number of children gets the least property. Wow. Compared to the household with more children. So of course that's a problem. Yes.
Wow, interesting, interesting. Okay, well, thank you so much for that. But as we wrap up, because my director tells me we're out of time, Ruth, how can one actually go about writing a will? What would you advise?
What I would advise? Engage a lawyer. The reason you would engage a lawyer is to avoid having those instances where a will is invalidated for formal validity. You know, you've not signed the right place, or it's been done in a certain way, there are no witnesses, you know. Those issues are issues that can easily be, you know, solved when you have a lawyer present. They can advise you the best way to do it. They can advise you, you know, whatever you're supposed to do, whether the property can actually be subjected to that will, to avoid the situation where you've put property in a will and it's later said that it cannot be subjected to a will, so you've really done nothing. So basically engaging a lawyer is very important. It might cost you something, but it's in the long run you'll definitely
absolutely I love that. Thank you so much. Well
You're
said.
Very much welcome.
I'm so sure this information was so helpful, especially to individuals like my floor manager, Mr. Kayesu, who definitely plans on having more than one wife. But Kayesu, we sure hope that helped you, and all the best, darling, all the best. That being said, of course, if you do want to get more information, you can definitely get in touch with the Hello Day crew. We'll be sure to put you in touch with Wakili Ruth Kibebo in studio with us in the event, of course, that you want more information on our current discussion, which is all about last will and testaments. Thank you yet again, Ruth. We hope to see you in studio again.
Thank you so much.
Thanks a lot for watching Hello Day. My name is Shiko Kaitani. We'll see you bright and early from 7 a.m. with the rest of the gang. But of course, Hello Day kicks off at 9 a.m. right here on Y254.